Chairman, members of the committees, thank you for inviting me to testify before you in this very important joint inquiry. It goes without saying that the terrorist attacks of September 11th profoundly affected and changed each one of us and our nation forever. But the most grievously impacted are obviously the loved ones of those who were so wantonly murdered that day without warning. It is to them that we most owe whatever answers there are to be found for how it happened, and the assurance that we, as a government, have done and will continue to do everything in our power to prevent such human devastation from ever happening again. My limited knowledge on this very complex subject of international terrorism, I am honored to share with you for whatever use it may be to your inquiry. I've submitted a written statement which has been made part of the record, and I will just in my oral comments highlight a few of the points in the written statement. I would then be pleased this afternoon to answer any questions the committee has of me today or in the future as your work goes forward. To give just a little bit of context to start, let me describe briefly the international terrorism investigations and prosecutions of the United States Attorney's Office for the Southern District of New York. From the beginning of my tenure as United States Attorney in June 1993 to its last day in January of 2002, I, together with a number of extraordinarily dedicated and talented Assistant United States Attorneys, agents, and detectives from the FBI, New York City Police Department, Joint Terrorist Task Force, JTTF, were actively involved in the investigation and prosecution of international terrorists and terrorist organizations who were plotting to attack or had actually attacked Americans and American interests, both in the United States and abroad. No work in our office had a higher priority. The international terrorism work of the Southern District of New York United States Attorney's Office began with the investigation and prosecution of those responsible for the bombing of the World Trade Center on February 26, 1993, in which 6 people were killed and over 1,000 injured. The work also included the investigation and eventual indictment of Osama bin Laden, the leader of the al-Qaeda terrorist network, indicted first in June 1998 for conspiracy under seal before he or al-Qaeda had massively attacked anyone. A copy of that indictment is included with my statement, Mr. Chairman. Bin Laden and 22 other defendants were subsequently indicted in November 1998 for their role in the bombings of the U.S. embassies in East Africa on August 7, 1998. In which 224 totally innocent people, including 12 Americans, lost their lives. In addition to the prosecution of those who bombed the World Trade Center in 1993 and those who bombed our embassies in Nairobi, Kenya and Dar es Salaam, Tanzania in 1998, the Southern District of New York United States Attorney's Office also successfully prosecuted approximately 20 additional terrorist defendants for their roles in 3 other major terrorist plots, which were fortunately thwarted by law enforcement. The 1993 Day of Terror plot to blow up government buildings and other structures in New York City, the 1994 Manila air plot to blow up a dozen U.S. jumbo jets flying back to America from the Far East, and then the December 1999 Millennium plot of Ahmed Rissam, an Algerian terrorist trained in al-Qaeda camps in Afghanistan, to detonate a bomb at the Los Angeles airport. In 2001, the Seattle United States Attorney's Office successfully prosecuted Rissam, and the Southern District of New York office successfully prosecuted 2 defendants who, from New York, provided material assistance to Rissam's plot in the form of money, credit cards, and phony identification papers. In all, the Southern District of New York United States Attorney's Office charged and convicted over 30 defendants for international terrorism. There were no acquittals. All of the defendants are serving life or very lengthy prison sentences without the possibility of parole. There are, however, fugitives still at large in several of the cases, including bin Laden himself, who as of September 11th had been under indictment for over 3 years and on the FBI's 10 most wanted list for approximately the same amount of time. 15 of the 22 terrorists on the most wanted terrorist list announced by President Bush on October 10, 2001, are fugitives in the Southern District of New York cases. 13 from the embassy bombings case, including not only bin Laden, but much of the leadership of the al-Qaeda terrorist organization. One defendant from the 1993 bombing of the World Trade Center, Abdul Rahman Yassin, who fled New York like Ramzi Youssef did on the day of the 1993 Trade Center bombing, and who, as you may have seen, was recently interviewed on 60 Minutes in a broadcast televised from Iraq. And one defendant from the Manila air plot, Khalid Sheikh Mohammed, who has been widely reported in the media to be one of the major planners of the September 11th attacks. Now I will speak to when the threat of international terrorism was regarded as a threat to and in America, and explain the particular importance in all of this to the day of terror plot. Certainly by the time our embassies in East Africa were bombed in 1998, we as a government knew a great deal about the threat posed by bin Laden and al-Qaeda to America, and at least by the time of the embassy bombings indictment filed in 1998, much of that knowledge was indeed a matter of public record. But the high risk that international terrorism and terrorists pose to America, both in America and abroad, was known and appreciated as a significant threat from at least 1993. The bombing of the World Trade Center on February 26, 1993 itself, of course, represented a dramatic incident of international terrorism that Ramzi Youssef, one of its masterminds, had brought from abroad to America. But it was, at least for us, the follow-on terrorist plot in 1993, the day of terror plot, to blow up in a single day the Lincoln and Holland tunnels connecting New York and New Jersey, the George Washington Bridge, the United Nations, and the New York FBI office in Lower Manhattan, that led us in the Southern District of New York, United States Attorney's Office, and the FBI to conclude that international terrorism was a long-term, highly dangerous risk to the safety and national security of the United States. The FBI and other public officials testified to this risk and spoke about it publicly to citizens groups. Prior to September 11th, I also personally gave several talks discussing specifically the point that international terrorism had come from abroad to America and posed a significant continuing threat to America, both at home and abroad. A copy of one such talk is included with my written statement. The day of terror plot, headed by the blind cleric and leader of the Gamat terrorist organization, Sheikh Omar Abdel Rahman, was fortunately foiled by the New York FBI and the JTTF because they had been able to infiltrate that terrorist cell, which was operating in the New York, New Jersey metropolitan area, with an informant posing as an explosives expert. As a result, that plot could be and was carefully monitored and stopped before it could come to fruition. The evidence necessary for the successful prosecution of Sheikh Rahman and 11 of his followers was also obtained. It was, in short, a very successful prevention and prosecution effort by the New York FBI and the Joint Terrorist Task Force. The Day of Terror plot case thus illustrates one point I do want to make today, and that is, at least from our perspective, we viewed the terrorist investigations and prosecutions we did from 1993 through 2002 as a major prevention tool. Everyone's goal was to thwart plots before they occurred and to neutralize dangerous terrorists so that they could not attack in the future. In that effort, we worked very closely with the FBI and especially later the CIA and other intelligence agencies to ensure that the first priorities were always prevention and national security. When criminal investigations and prosecutions could aid the overall national security effort, our office willingly and aggressively offered our help. From my vantage point, the counterterrorism strategy of our country in the 1990s was not, as I've read in the media and heard a little bit of today, criminal prosecutions. Rather, as I saw it, criminal prosecutions were one tool in our counterterrorism efforts, a tool that certainly neutralized for life a number of very dangerous international terrorists, including Ramzi Youssef, a mastermind of the 1993 Trade Center bombing, and the architect of the Manila air plot, as well as Sheikh Omar Abdel Rahman, the leader of the Day of Terror plot and head of the Gamat terrorist organization that later joined forces with al-Qaeda. It was also, of course, our hope that the indictment of Osama bin Laden and the leadership of al-Qaeda in 1998 would result in the apprehension and neutralizing of these and other terrorists who posed and still pose very grave threats to the safety of America and the world. But none of us considered prosecutions to be the country's counterterrorism strategy or even a particularly major part of it. In addition to cementing our view that international terrorism posed a significant threat to us here at home, the Day of Terror plot was also important for some other reasons. First, it showed the foothold that international terrorists had or were gaining in the United States. All of the defendants in the case were residing in New York and New Jersey. Some were here in the United States legally, some were here illegally. I should say that there is no doubt in my mind that it is a critical matter of national security that our immigration policies and procedures be dramatically enhanced. A number of the terrorist defendants in the Southern District of New York cases, including Ramzi Youssef, for example, entered the country illegally. Others remained in the country illegally after they'd come in legally, only to surface when they participated in a terrorist attack in the United States, like the bombing of the World Trade Center. I guess the Sheikh himself, the leader of the group, was preaching his anti-American rhetoric in 1993 in mosques in Brooklyn, New York, and Jersey City, New Jersey. Second, and even more importantly, the Day of Terror plot illustrates the importance of the infiltration of terrorist cells by human sources and informants. Such infiltration is, in my view, one of the most effective means of preventing terrorist attacks. It is not easy to do. There are cultural and expertise barriers that must be overcome. Nevertheless, in my view, whatever can be done to enhance the FBI's and the intelligence community's ability to develop human sources and operatives capable of infiltrating terrorist cells should be done, both in the United States and around the world. At the conclusion of the trial of the Day of Terror plot, which was in 1995, I made the decision to form an international terrorism unit in the Southern District of New York, United States Attorney's Office, and to staff it initially with those half-dozen assistant United States attorneys who had been involved in the investigations and prosecutions of the 1993 Trade Center bombing, the Day of Terror plot, and the Manila air plot. To my knowledge, that terrorism unit was the only one in a United States Attorney's Office prior to September 11th. I personally supervised our terrorism unit. I made the decision to establish a permanent terrorism unit because we had concluded that the risk of future terrorist attacks and plots was high and long-term. And because, as a result of the knowledge we and the New York FBI and JTTF had gained as a result of the two back-to-back 1993 international terrorism cases, we had of necessity amassed a great deal of intelligence about various terrorists and terrorist networks that we did not want to lose as we went forward. We wanted to pursue all leads of other terrorist conspiracies and attacks. So unlike with most other kinds of prosecutions, we did not close up shop after the Day of Terror plot defendants were convicted and went to jail. We did not wait for the next attack. We, together with the FBI and the JTTF, actively continued to investigate other possible terrorist crimes and conspiracies to try to learn more, to follow any lead that suggested itself. While it is certainly the reality that not every terrorist attack can be prevented, our objective and priority must always be a perfect prevention success rate. We must do whatever is lawful in our effort to achieve that. You have asked in your letter to me about the role and effectiveness of criminal prosecutions in the fight against international terrorism. I think, as the Southern District of New York cases demonstrate, criminal prosecutions of terrorist defendants have been and can be effective tools to deal with terrorists who commit federal crimes and as to whom there is sufficient available evidence to prove such defendants' guilt beyond a reasonable doubt under the rules governing criminal trials in the American criminal justice system. Prosecutions can also lead, and did lead, to cooperating defendants who provided invaluable intelligence on the terrorism threat, as well as trial testimony. These prosecutions also neutralized for life, or many years, a number of very dangerous terrorists who would have otherwise continued to commit further terrorist acts. Some bombs were thus undoubtedly not built and detonated. Some planes were not blown up, and some people were not assassinated. That is obviously a good thing. But criminal prosecutions are plainly not a sufficient response to international terrorism. For that, we plainly need more comprehensive measures, and most especially, a strong and continuing military response. That is my view today, and that was my view prior to September 11th. Just as one example, and I'll only give one, of the limitations of the criminal justice system in dealing with international terrorism. Criminal prosecutions of international terrorists have limited deterrent effect. When thousands of international terrorists all over the world are willing, indeed anxious to die in the service of their cause, we cannot expect prosecutions to effect significant deterrence. Each of the Southern District of New York cases I've mentioned in my statement followed the one before it, culminating most recently in the attacks of September 11th. Prosecuting and convicting Ramzi Youssef for the 1993 World Trade Center bombing and the Manila air plot did not deter other would-be terrorists from bombing our embassies in East Africa in 1998, or from hijacking and flying those planes into the World Trade Center and the Pentagon on September 11th. You have asked also about the sharing and dissemination of information related to the threat of international terrorism. Your question is whether, prior to September 11th, the information about international terrorism gathered by the various parts of our law enforcement and intelligence communities was shared and disseminated sufficiently. This is one of many areas where I must defer to others who have the complete picture. While we certainly had concerns about this issue in our office, my general impression was that the information and evidence developed in at least the terrorism investigations and prosecutions in the Southern District of New York was generally shared by the FBI with the intelligence community and other parts of our government, as well as with local and state authorities. Much of the information was in fact developed by the intelligence community, and local and state agencies worked directly on the JTTF, which worked each of the Southern District of New York cases. I cannot speak to what information the intelligence community may have had that was not shared with the FBI or law enforcement generally, if any, but I can say that the relationship was a very positive and cooperative one. The CIA in particular was of invaluable assistance in the Southern District of New York cases and investigations. I can also say from my personal experience as a prosecutor and U.S. Attorney for many years that under the leadership of FBI Director Louis Freeh and Director George Tenet of the CIA, the working relationship and cooperation between the FBI and the intelligence community at the highest levels was excellent, and even more importantly, we saw a sea change of improvement in the 1990s in the ranks of the agencies as well. Nowhere was this cooperation more apparent and productive than in the investigation of the terrorist threat posed by al-Qaeda and Osama bin Laden. One other question on information sharing that I should speak about, and that is whether the grand jury secrecy rules embodied in Rule 6E of the Federal Criminal Procedure, Rules of Criminal Procedure, prior to their amendment by the USA Patriot Act, impeded the sharing of information between the law enforcement and the intelligence community. My view is that Rule 6E was not a significant barrier to the sharing of information developed in the Southern District of New York cases and prosecutions. It could have been, but it was not. Grand jury secrecy rules do not appear to me to have impeded the sharing of information in the Southern District of New York investigations and prosecutions for several reasons. First, the vast majority of information obtained was not obtained through the grand jury, but by non-grand jury means of investigation to which the grand jury secrecy rules do not apply. Second, if any relevant information was obtained through the grand jury to which Rule 6E might apply, we were generally, and I think always actually, able to obtain it through alternative means as well so that it could be shared. Third, quickly over time, the information we and the FBI obtained in our investigations became a matter of public record through publicly filed indictments and other court documents, as well as public trials with detailed written transcripts and publicly filed exhibits. I illustrate what I'm saying now in my longer written statement with the East Africa Embassy bombing indictment in 1998 and all the things that were publicly known in 1998. One final point on this, our constant mindset in the U.S. Attorney's Office was to try to maximize the sharing of information real time so that it could hopefully be used by others to gain further information and, most importantly, to be used to possibly detect terrorist plots and to safeguard against any threats posed. This leads me to my final point about information sharing, but in the other direction. And I have to say, if I were to single out the most significant concern that I had about our counterterrorism efforts prior to September 11th, dating from at least 1995, it was that I feared we could be hampered in our efforts to detect and prevent terrorist attacks because of the barriers between the intelligence side and law enforcement side of our government. Some of these barriers were, and perhaps still are, statutory. Some were, and perhaps still are, cultural. Some were and still are court-imposed. Some were and may still be voluntarily imposed by the agencies by way of guidelines to assure compliance with all legal requirements and to make an adequate record of such compliance. Our intelligence community is charged with gathering foreign intelligence to protect the national security. The FBI has a foreign counterintelligence function and law enforcement or criminal function. Historically, those functions have been separately staffed. International terrorism, however, cuts across both of these functions. It does not fit as neatly into one category or the other as espionage may have during the Cold War. Much of the information gathered by the intelligence community is most often also evidence of a possible criminal conspiracy or other crime. Much of the information gathered by law enforcement as evidence of a terrorist-related plot is also most often foreign intelligence information relevant to the national security. And yet, at least as things were done in the 1990s through September 11th, as we perceived it, that evidence, if gathered on the intelligence side, could not be shared with prosecutors unless and until a decision was made in the Justice Department that it was appropriate to pass that information over the wall to prosecutors, either because it showed that a crime had been committed that needed to be dealt with by an arrest or further overt investigation, or because evidence of such crime was relevant to an already ongoing criminal investigation. Because of this structure and these requirements, I do not know even today what evidence and information might have been relevant to our international terrorism investigations that was never passed over the wall. I don't know that there is any, but I don't know that there isn't any either. To make a decision to pass information over the wall requires, in the first instance, a recognition of what that information is and what its significance is. In the area of international terrorism, this is a very difficult task, made more difficult by a combination of language and cultural barriers, coded conversations, literally tens of thousands of names of subjects that are confusing and look alike, and an unimaginably complex mass of snippets of information that understandably may mean little to the people charged with reviewing and analyzing the information and deciding whether to recommend that it be passed over the wall. A prosecutor or criminal agent who, as it happens, has for many years been investigating particular terrorist groups or cells, and who has thus amassed a tremendous body of knowledge and familiarity with the relevant names and events, might well recognize as significant what seems to other conscientious and generally knowledgeable agents or lawyers as something essentially meaningless. What can happen, and I fear may have happened, but I don't know that, is that some relevant information that could have been passed over the wall wasn't, and thus an opportunity could have been lost to make a connection that might have led to a further investigative step that might have led to the detection of an ongoing terrorist conspiracy. We must, in my view, do everything conceivably possible to eliminate all walls and barriers that impede our ability to effectively counter the terrorism threat. That they must change. If the law must be changed to do that, I would change the law. Indeed, I believe the Justice Department and the Congress thought that the law had been changed to help address this problem by the USA Patriot Act. A recent decision by the Foreign Intelligence Surveillance Act Court, the FISA Court, now in appeal, however, suggests otherwise. The FISA Court decision also alludes to certain enhancements to the wall that the FISA Court imposed prior to September 11th, effectively making the court the wall in certain international terrorism investigations. The walls that so concerned us throughout my tenure as United States Attorney thus were built higher prior to September 11th. While we were not made privy to the full rationale for this decision, because we're on the other side of the wall, and we certainly would not condone any misrepresentations, inadvertent misrepresentations to any court or any abuse of the FISA authority, raising the walls did concern us greatly from a public safety point of view. We voiced those concerns with officials in the Department of Justice prior to September 11th. We do not know what, if any, relevant information was kept behind those walls. Incidentally, when I was asked after September 11th by the Justice Department and FBI Director Bob Mueller what legislative changes we would recommend, we made a number of recommendations, but what I said was the single most important point is to get the walls down between the intelligence and the law enforcement community. That remains my very strong view today. In my written statement, offered a number of other recommendations, but the single most important recommendation I would make to the committees would be to address the full range of issues presented by the bifurcation of the intelligence and law enforcement communities and functions as they operate in international terrorism investigations, including the permissible use of FISA and the dissemination and use of the product of FISA searches and surveillances. And so I will end there by thanking you very much for this opportunity to share my perspectives.